everybody, a very warm welcome to all of you present here. A very good afternoon to all of you. Now, today we present before you the thorough newspaper analysis for 5th of March 2024. This entire video series, as you know, it is brought to you by LawSikho. So now let's quickly head to the agenda for today. First of all, we have the editorial segment. Here we talk about an important article that featured in Indian Express. This is going to be followed by discussion around important news updates for the day. And lastly, we talk about the news updates of the day. So let's start with the editorial article. The title of this article is JMM Bribes for Votes Ruling, How the Supreme Court has Interpreted the Privilege which is available to lawmakers. Now, this is an important article. Why? Because Monday को ही Supreme Court ने इस पूरे मैटर पर अपनी जजमेंट दी है, which is कि अगर कोई लॉ मेकर है, let's say उन्होंने bribe accept करी, and following that, the lawmaker made a particular speech, cast a particular vote in the house concerned, and अगर उन पर फिर हम criminal proceedings initiate करें, anti-corruption proceedings, let's say, तो can the lawmaker come forward and say कि मैं तो immune हूँ, I have immunity which is provided to me against criminal prosecution by 2 articles of the Indian Constitution. What are those articles? वो हम आगे देखेंगे. So इसी के रिस्पेक्ट में सुप्रीम कोर्ट ने रिसेंटली एक रूलिंग दी है. वहां पर सुप्रीम कोर्ट ने अपनी एक अर्लियर रूलिंग को भी ओवररूल किया है. We've done a series of articles on this entire issue, and this is a continuation of that only. So without further ado, let's start with the article. So the title of this article, as we've already noted, is JMM Bribes for Votes Ruling, How the Supreme Court has Interpreted Privilege for the Lawmakers. Let's read and have an understanding of the context of this entire matter. So see, recently, which was on Monday, 7-judge Constitution Bench of the Honorable Supreme Court, which is, of course, headed by Honorable the Chief Justice of India, D.Y. Chandrachud, has ruled that lawmakers who are facing bribe charges in connection to their speech and votes in the House, they cannot be immune from criminal prosecution. So in doing so, essentially, the court held the claims of parliamentary privilege by the lawmakers, it can be subjected to judicial review, and only Parliament, it cannot be the last authority having the last say on this matter. So essentially, what has happened here? अगर किसी lawmaker ने, be it an MP or an MLA, उन्होंने अगर bribe accept करी है, and following that, they've casted a certain vote, made a certain speech, they cannot come forward and say, I am immune from criminal prosecution. That immunity is not available to such lawmaker. This is what the crux of Supreme Court ruling is. यहाँ पर हमें ये ध्यान रखना है कि this is a 7-judge bench, Constitution bench. So strength क्या है? What is the bench strength here? 7 judge. Who are the members of this bench? Of course, Honorable the Chief Justice of India, D.Y. Chandrachud. Honorable judges. Who are those judges? Justices A.S. Gunappa, M.M. Sundaresh, P.S. Narasimha, J.B. Pardiwala, Sanjay Kumar, and Manoj Mishra. So they form this 7-judge Constitution bench. Here, this bench, it also overruled its 1988 decision. What was that case? What was the ratio of that case? So the name of that matter is P.V. Narasimha Rao versus the state. And in this particular case, essentially, by a majority of 3:2, the Supreme Court ruled this. So the majority 3 bench, it ruled that these lawmakers who are accused of accepting bribery, they are immune. So they have the immunity. They can come forward and say that, I am immune from criminal proceedings. The court in that matter noted that we are acutely aware of the fact that this is a matter of serious concern. These offenses are very serious, but the provisions of the Constitution, they cannot be construed narrowly. So जो Constitution के provisions है, उनको हम एक narrow interpretation नहीं दे सकते, although we are aware of the fact कि ये जो offense है बहुत ही severe and serious nature के offense है. जो minority which was constituted by 2 judges, उन्होंने however ये held किया that no, you cannot claim this immunity. Now let's talk about the present matter. Let's very briefly deal with the facts of this case. So होता क्या है, इसके लिए हम जाते हैं 2012 में. In 2012, a member of the Jharkhand Mukti Morcha, the political party जिसके initials यहाँ पर है JMM, इनकी एक politician है सीता सोरेन. She was alleged, उनके ऊपर ये allegation था कि आपने bribe ली है for casting your vote in a certain fashion in the Rajya Sabha election of 2012. As a result, the CBI came in. The CBI then, post its investigation, filed a charge sheet. This happened in 2012. Now, because she was aggrieved by the filing of the charge sheet, तो उन्होंने क्या किया? She approached the Jharkhand High Court. किस mechanism में? With a quashing plea. ये आपने बहुत बार सुना होगा कि अगर आपके खिलाफ let's say कोई FIR lodged है जो कि आपको पता है कि is frivolous, there is no substance in it. तो what you do? You approach the High Court with a quashing plea. फिर High Court जो है अपने inherent power को exercise करते हुए अगर आपका जो stand है वो बनता है तो वो quash कर देते हैं. तो similarly, she also sought quashing of the charge sheet. And what was her bone of contention? The plea of her contention, the core of it, that I have immunity given to me by the Indian Constitution and I cannot be criminally prosecuted here. So the High Court, however, dismissed this plea and therefore the matter reached the Honorable Apex Court. Now see, please understand, before the Supreme Court, this is how the matter went. So first it went to the 2-judge bench, then it went to a 3-judge bench. The 3-judge bench noted that already 1988 में एक similar case का decision आ चुका है जिसका बहुत ही margin से split verdict है, which is 3:2. So therefore उन्होंने ये सही समझा कि हम इसको 5-judge constitution bench को रेफर करते हैं, and that was done. जब 5-judge के सामने ये मैटर आया तो उन्होंने देखा चीफ जस्टिस ने कि इसमें जो ये अप्रिसिएशन ऑफ लॉ है या फिर जो रूलिंग है नरसिम्हा राव की जजमेंट की, इट इज नॉट साउंड. सो देयरफॉर 2 जजेस को और इंडक्ट करा गया ताकि अगर ओवररूल करना पड़े तो वो स्ट्रेंथ मैनेज हो पाए. 5 की ओवररूल करेंगे तो 7 की स्ट्रेंथ वुड बी रिक्वायर्ड. सो नाउ हियर दिस इज द एंटायर गैमेट ऑफ फैक्ट्स जिससे कि ये केस सुप्रीम कोर्ट के पास आया. अब हम समझते हैं वो लीगल प्रोविजंस जो कि इम्यूनिटी देती है. तो इसके लिए हमारे पास 2 आर्टिकल्स है. वन इज आर्टिकल 105 क्लॉज 2 जो कि एमपीज के कंसर्न में है. देन वी हैव 194 क्लॉज 2 which is with respect to the legislative assembly के members, which is an MLA. So what does 105 clause 2 say? It says or states, no member of the parliament shall be liable to any proceedings in any court in respect of anything which is said of any vote which is given by him in the parliament or any committee thereof. So यहाँ पर essentially यही कहा गया है कि criminal proceedings आपके against नहीं होंगी कब? If you have said something, there is any speech in the house or any committee, you've cast any vote in any parliamentary committee or in the house, so then you are immune. Similar provision किसके रिस्पेक्ट में? MLAs के रिस्पेक्ट में कहाँ मिलेंगे आपको? 194 clause 2. So this is what the Supreme Court essentially had to interpret. अब हम देखते हैं कि सुप्रीम कोर्ट ने इंटरप्रिटेशन अब एक्चुअली किया कैसे. सो पार्लियामेंट्री प्रिविलेजेस की कोर्ट ने एक हिस्ट्री ट्रेस करी और उन्होंने एक डिस्टिंक्शन निकाली कि जो यूके में पार्लियामेंट्री प्रिविलेजेस है और जो इंडिया में पार्लियामेंट्री प्रिविलेजेस है वो दोनों कैसे आए, उसमें एक डिफरेंस है. व्हाट इज दैट डिफरेंस? सो ट्रेसिंग द हिस्ट्री ऑफ पार्लियामेंट्री प्रिविलेजेस इन इंडिया, the Supreme Court said that unlike the House of Commons in UK, India does not have ancient and undoubted rights vested after a struggle between the Parliament and the King. तो जैसा कि यूके में हुआ था, इंडिया में वैसा नहीं है कि एक बहुत ही लॉन्ग स्टैंडिंग स्ट्रगल चला बिटवीन पार्लियामेंट एंड किंग एंड फिर प्रिविलेजेस मिले. हमारी कंट्री में तो इनफैक्ट क्या हुआ था, these rights in India even during the colonial times, they've flown from a statute. So even during the colonial times, we did not fight for this right. There was no long-standing conflict or struggle. It was given to us via a statute. And जब हमें independence मिली and we transitioned into a republic, we had our own constitution. So then this right, it post our independence, it transitioned to a constitutional privilege. So starting emanating from a statutory privilege, it transitioned to a constitutional privilege. So this the court cited as a reason to interpret privilege in a way that fits with the larger ideals of the constitution. So the court said that this constitutional privilege, it has to fit in the larger scheme of the spirit of the constitution. Now, secondly, the court said that there are two components of parliamentary privileges. What are those? One is what the house exercises collectively as a house. उसमें कौन से powers आते हैं? House के पास power है कि वो अपनी contempt के लिए किसी को punish कर सकते हैं. So punish for its contempt, then power to conduct its own affairs being the second, and so on and so forth. Second element is for individual rights. Let's say, how do these rights are exercised? Members, they have the freedom of speech. So this is their right. And this, the court said, it has to pass a test. The court said that if you are making a certain speech, you have a right to make that. But if you want to claim an immunity with respect to your act, then you have to satisfy a test. What is that test? कि जो आपका एक्ट है, जिसके रिस्पेक्ट में आपने ये काम किया है, जिसके रिस्पेक्ट में अब आपको जो आपका एक्ट है, जिसके रिस्पेक्ट में आप ये प्रिविलेज क्लेम करना चाहते हो, इज इट एन इम्पोर्टेंट एलिमेंट ऑफ योर ऑफिशियली ड्यूटी का डिस्चार्ज. So essentially, the court said that it cited the necessity test, which means that for a member to exercise a privilege, the privilege must be such that without it, they could not discharge their functions. Naturally, accepting bribe, the court said, and very rightly so, that naturally accepting bribe cannot be said to be necessary to discharge one's functions as a lawmaker. So a lawmaker cannot come forward and say that, taking bribe, it is an essential element for me to discharge my official functions. So no, a lawmaker cannot come forward and say so. So therefore, the court said that here the immunity is not available. So naturally, accepting bribes, it cannot be said to be necessary to discharge one's functions as a lawmaker, unlike, for example, having the right to free speech. This is an important observation by the Apex Court, which I would like to read and quote. Corruption and bribery of members of the legislature, it erode the foundation of Indian parliamentary democracy. It is destructive of the aspirational and the deliberative ideals of the constitution, and it creates a polity which deprives its citizens of a reasonable, responsive, and representative democracy, the court said. Further, this was an important aspect of the case. So, कोर्ट के पास एक एलिमेंट ये आया इंटरप्रिटेशन के लिए. सपोज किसी लॉ मेकर ने ब्राइब तो ले ली, बट उन्होंने उस ब्राइब की जो ब्राइब गिवर की डिमांड है उस पर एक्ट नहीं किया, और उन्होंने जो स्पीच दी या जो वोट कास्ट किया उसमें खुद की चॉइस एक्सरसाइज करी, तो क्या तब भी हम जो है उनको इम्यूनिटी नहीं देंगे? तो इसके रिस्पेक्ट में कोर्ट मेड अ रेफरेंस टू सेक्शन 7 ऑफ द प्रिवेंशन ऑफ करप्शन एक्ट. लेट्स सी दैट सेक्शन, इट्स वेरी इंपॉर्टेंट. So it deals with offense relating to public servants being bribed. The section says, the mere obtaining, accepting, and attempting to obtain an undue advantage with the intention to act or forbear from acting in a certain way, it is sufficient to complete the offense. And it is not necessary that the act for which the bribe is given, it is actually performed. तो essentially, let's take an example of IPC. I'm assuming आप में से काफी लोगों ने IPC पढ़ ली होगी या फिर आप पढ़ रहे होंगे. You're in the process of it. IPC में जैसे दो offenses की example लेते हैं. One is murder, another is criminal intimidation. Murder में क्या होता है? Actus reus, mens rea. Mens rea is your all of those mental elements, intention, then you have knowledge, intention of bodily injury, all of those things, right? So then that is one. And next is, so I'm sorry, I think my video went off. Okay. So one element is murder. Murder mein, what is the actus reus? That you have caused murder. Whoever causes murder. So you have to cause the murder. That would be the actus. But in criminal intimidation, if you're just threatening somebody that I'm going to cause injury to your person, property, reputation, then that threatening itself is sufficient to constitute the offense of criminal intimidation. So similarly here, in section 7, mere acceptance of bribe with the intention to act or to abstain from acting at the behest of the bribe giver, it is sufficient to constitute the offense. So therefore, this means that merely accepting a bribe, it is an offense as it is, and it does not depend on whether the public servant has acted differently later. The court said that it would be a violation of Article 14 to create an illegitimate class of public servants which is afforded extraordinary layer of protection. The court said that this classification would fall foul under Article 14. Why? Because ये classification जो है ये manifestly arbitrary हो जाएगी. Now further next aspect for discussion is this. Now see, अब ये तो clear है कि lawmakers जो वो immunity तो नहीं claim कर सकते. Now what do we do with them? What is the extent of court's involvement? So here, one of the contention by the party was that the Supreme Court's interference is unwarranted because Parliament के पास खुद के पास, it has the mechanism of punishing for its contempt and all of these. So the court said that the court's jurisdiction to prosecute a criminal offense and the authority of the House to take action for a breach of discipline, it operate in distinct spheres. Thus, judicial proceedings cannot be excluded merely on the ground that because bribery charges can also be treated by the House as contempt or as a breach of its privilege. The court further highlighted that while proceedings in the House are conducted to restore the dignity of the House, criminal trial, it emanates from the power of the state to prosecute offenders who violate the law of the land, and it is governed by procedural safeguards, rule of evidence, and the principle of natural justice. So court ने कहा कि all of these they operate in distinct spheres. So that's about this article, and now we proceed to the next segment for today.
Okay, so now we proceed to the national news update for today, and the first update that we have, it is about Flipkart launching its own UPI handle. So let's see. Flipkart, it has unveiled its UPI handle to boost India's digital evolution. Flipkart, it has launched its UPI, which is the Unified Payments Interface handle, to enhance digital payment offerings to all its users, including the e-commerce majors over 500 million base of customers. This is powered by Axis Bank, and it will be available currently to all the Android users. Now, how can you access it? It can be done by customers by registering themselves for UPI with the handle name @FKAccess, and they can thereafter, do fund transfers, check out payments using the Flipkart app. Now, if I were to give you an idea of how large of a base does India have in the UPI payment system, so in 2023, UPI processed over 117 billion transactions. Now, the next update, it is also an important one. So recently, Amit Shah, the Honorable Home Minister and also the Cooperation Minister, he launched an organization, he launched a corporation, a body. What is that? It is called Urban Cooperative Finance Development Corporation. So this body, it is going to act as an umbrella body over what? Over the urban cooperative banks. And what its function is? It is to set up one urban cooperative bank in each town. So this body, it has been set up with the aim of setting up one urban cooperative bank in each town. So a question might come in your exam as to, which is the recently launched body, the umbrella body for this purpose. So your answer should be this body. So the Home Minister, the Corporation Minister, he said that cooperative banks, they should upgrade themselves by providing all of these facilities. What are these? ATM facility, credit and debit cards, clearing system, maintain the limit. What is that limit? The SLR limit, the statutory liquidity ratio limit, and refinancing. This corporation, it has received the RBI approval to function as a non-banking finance company and a self-regulatory organization for the urban cooperative banks. Its main function would be what? A, to bring professionalism in all of these banking institutions, and secondly, to ensure that these cooperative banks, they comply with the Banking Regulations Act. Moving on to the next update. So this is also an important update. Recently, the Prime Minister, he dedicated to the nation a fertilizer plant. What is the name of the fertilizer plant? Where is its venue? These are two important exam pointers. So the name is Hindustan Urvarak and Rasayan Limited, Sindri Fertilizer Plant. Where is its base is? It is at Sindri in Dhanbad district of Jharkhand. The foundation stone for its construction, it was launched and laid way back in 2018. And this is a list of data to give you an example of how much is the gap in production of fertilizers domestically. So, अभी जो हमारी current यूरिया की requirement है, that stands at 360 lakh metric tons. 2014 में हमारा domestic production कितना था? It was 225. And currently the production has gone up to 310, but still एक gap है और उसी gap को bridge करने के लिए this particular plant is going to play an important role. Next is an update in the defense segment. This is also an important one. So this is with respect to exercise Samudra Laksamana. So what are the parties involved? Navy of India and Navy of which other country? Malaysia. Very important for exam point. What is the name of this exercise? Samudra Laksamana. कब से कब शुरू हुई, कब खत्म हुई? So this was from 28th of February and it continued until March 2nd. कहाँ से हुई? It was at or off the coast of Visakhapatnam. Now, what were the ships involved here? So this was a collaborative effort involving the participation of Indian naval ship called Kiltan and Royal Malaysian ship KD Lekir. What is the aim of this exercise? Again, जो कि mostly सारी defense related exercises का aim and purpose होता है. It is harboring professional interaction between the two armies of India and that of Malaysia. Now moving on to the international segment for today. So this update comes from Pakistan and इसके रिस्पेक्ट में हमने कुछ ही दिन में कुछ दिन पहले एक डिटेल्ड स्टोरी करी थी एज इन व्हाट इज द पॉलिटिकल सिचुएशन इन पाकिस्तान, व्हाट आर द पार्टीज इन्वॉल्व, जो अभी करंट इलेक्शन हुआ था उसका क्या मैंडेट रहा. तो एसेंशियली अभी रिसेंटली पाकिस्तान में जो है इलेक्शंस हुए एंड उसमें किसी भी पॉलिटिकल पार्टी को एक क्लियर कट मेजोरिटी नहीं मिली जिससे कि वो अपनी एक गवर्नमेंट बना सके. तो जब मेजोरिटी नहीं मिलती तो क्या ऑल्टरनेटिव होता है? दैट यू फॉर्म अ कोलिशन गवर्नमेंट. So the same was done here, and now the candidate who's been chosen as the Prime Minister, the name has been declared. So Pakistan, Shehbaz Sharif takes oath as the Prime Minister. Shehbaz Sharif has become the Prime Minister of Pakistan for a second time to lead a coalition government after he comfortably won a majority. So what are those two parties जो कि involved है यहाँ पर, वो देखते हैं. Shehbaz 72, he was the consensus candidate of these two parties, the Pakistan Muslim League Nawaz, PMLN, and the Triple P, which is Pakistan People's Party. He received 210 votes, which is 32 more than the votes needed for him to become a Prime Minister. Because Pakistan की जो parliament है उनकी strength कितनी है? This is 336. The National Assembly Speaker, Sardar Ayaz Sadiq, he announced the result, appointing him as the Prime Minister, and he is the 24th Prime Minister. अगर हम इनकी पिछली टर्म की बात करें तो there also he was heading a coalition government and the tenure is April of 2022 to August of 2023. Now, these two are also updated in the international segment. One is in the segment of science and tech, while the another one is related to sports. So, SpaceX NASA successfully launched manned Crew 8 mission to International Space Station. SpaceX and NASA on Sunday, they successfully launched their joint Crew 8 mission to the International Space Station. From where? This is also a question point. It might come, which is the NASA's Kennedy Space Center in Florida. Together, NASA and SpaceX, they launched a crew of how many more members? 4 members to the ISS, which is the International Space Station, in the Dragon spacecraft, marking SpaceX's 8th crew rotation mission to the ISS within NASA's Commercial Crew program. Now, this was the third attempt. The earlier 2 attempts, they did not succeed. This is a list of all the people on board. So let's see who are those people. The NASA astronauts are Commander Matthew Dominic, then we have pilot Michelle Brett, mission specialist is Jeanette Epps, and we have Russian cosmonaut, who is that? Alexander Grebenkin. So he was also acting as the mission specialist. So these were the members on board. It was the first mission to the ISS for all except one, who is Barrett. Now this information is not needed. Okay, so let's proceed to the next update. Minaur, he beats Ruud, first player to win back-to-back titles in Mexico since 2012. Very important update. Alex de Minaur, he beat Casper Ruud to become the first player to win back-to-back titles in the Mexican Open since 2012. So consecutively he's been winning. The 25-year-old Australian, he won his 10th match. So this is his consecutive 10th win. Mexico Open, it was nearly cancelled because of devastating hurricanes, but eventually they managed to pull this event off. So please remember both of these names for the purpose of your exams. Now this has brought us to the legal news update segment for today. And first we have an update from Calcutta High Court. And then the second update, it is the same that we covered in our editorial only, which is with respect to the MP MLA privileges. So let's talk about the Calcutta High Court ruling first. The name of this particular case is SRMB Srijan Limited versus Great Eastern Energy Corporation Limited. High Court concerned is what? Calcutta High Court. Let's see the core of this ruling. Mere silence affecting willingness of person to enter contract, it is not fraud unless it amounts to active concealment. So it pertains to fraud, Indian Contract Act. Let's see. The Calcutta High Court has recently held that mere silence of a party which affects the willingness of a person to enter into a contract, it is not fraud unless the circumstances of the case are such that it is the duty of the person keeping silence to speak, or unless the silence, it is itself equivalent to speech. So unless your silence amounts to speech, or unless the circumstances of the case are such that it becomes your duty, you are duty bound to speak on matters with respect to which you are keeping silent, tab tak jo hai, you cannot say that it is constituting fraud. So while referring to section 17 subsection 2 of the Indian Contract Act, section 17 किसके बारे में बात करता है? It provides or it defines fraud. So let's have a look at this section first and then see कि court का क्या कहना था. So section 17 it says fraud means and it includes any of the following acts committed by a party to a contract or by his or with his connivance by his agent. So it can be committed by the party to the contract या फिर party to the contract अपने agent के साथ connive करके मिलके the act is being done. And what is the intention? Intention is to deceive another party to the contract. So or to induce the other party to enter into the contract. Deceive or to induce. Suggesting as an act, as a fact of that which is not true. So he's suggesting something as a fact which is not true by one who does not believe it to be true. Secondly, active concealment of a fact by one having knowledge or belief of that fact. Thirdly, is promise made without any intention of performing it. Fourthly, any other act fitted to deceive. Fifthly, any such act or omission as the law specifically declares to be fraudulent. So the concerned provision is second for us, where there is active concealment of fact by one party having knowledge or belief of that fact. Now there is an explanation which says mere silence as to facts likely to affect the willingness of a person to enter into a contract, it is not fraud unless the circumstances of the case itself are such that regard being had to those circumstances, it is the duty of the person who is keeping silent to speak, or unless his silence in itself is equivalent to speech. So this is what the Supreme Court has only held here. And the court further added, fraud also takes within its fold active concealment of a fact by the party who is having knowledge of the fact, or a promise made without intention of performing it, or any other act which is fitted to deceive. So यहाँ पर कोर्ट ने basically यही elements को elaborate किया है. It is relevant that section 17(2) contemplates active concealment, which points to deliberate non-disclosure with a premeditated intention to deceive the party or to induce the party to enter into a contract. So this is what the Honorable Apex Court has held here. I'm sorry, the Calcutta High Court has held. Now let's proceed to the Supreme Court's ruling. So in a landmark judgment, the Supreme Court on Monday overruled the ruling of 1988, which is in the case of P.V. Narasimha Rao, which in this judgment, it was held that members of parliament and legislative assemblies could claim immunity under Article 1052 and Article 194 Clause 2 of the Constitution for receiving a bribe in contemplation of a vote or a speech in the legislature. So this was the ruling of the case of P.V. Narasimha Rao, and the court has now overturned this ruling. So the background of the case is the same that we've already discussed. The 1998 judgment here by 3:2 majority, the Supreme Court held that the lawmakers accepting bribes, they can claim immunity. And this verdict, it was doubted when the appeal by Sita Soren came before the Supreme Court, and therefore matter went eventually to 5-judge bench and transitioned into a 7-judge bench. And here the Supreme Court held this, which is a member of parliament or a state legislature cannot claim immunity from prosecution on charge of bribe or a criminal court by virtue charge of bribe in a criminal court by virtue of these two articles. So the immunity is no longer available when the bribe matter is involved. What is the name of this case? Very evidently clear. Sita Soren versus Union of India. So that's all for today's TNA. We've come to an end of the TNA. In case you want to get access to free study material that we curate or the slides that have been used in this video, please feel free to join our Telegram channel. And how can you do so? You can click on the link which is given in the description of this video, or you can scan the barcode which is available on the screen. These are the point of contacts in case you want to get in touch with LawSikho. And the link based on yesterday's TNA, it is also made available in the description of this video. Please go ahead and attempt the same. Thank you so much. Thank you for being with us.